Chapter 7. Change of national and quasi-national domicile. 1. Acquisition of domicile of choice. Section 121. We now come to consider the subject of a change of domicile, which may occur in either of two ways: a. By the acquisition of a domicile of choice, or b. After a domicile of choice has been abandoned, by the reverter of the domicile of origin. It is proposed to consider the former branch of the subject in this chapter, and to confine the discussion for the present to cases of national and quasi-national domicile, leaving the question of a change of municipal domicile for subsequent discussion. Section 122. Domicile of origin more difficult to change than acquired domicile. 2 points must be kept in view throughout the discussion. 1. The acquisition of a domicile of choice may be either a. By the substitution of an acquired domicile for domicile of origin, or 6. By the substitution of one acquired domicile for another, and for the reasons given in the last chapter, domicile of origin is more difficult to change than acquired domicile. A change of domicile is always presumed against, but this presumption is particularly strong when the change in question is in derogation of the domicile of origin, especially if the domicile of origin corresponds with the place of birth and early education. Section 123. National domicile more difficult to change than quasi-national. 2. The change may be a. From one sovereign state to another, or b. From one province or state to another within the same sovereignty. The analogy of perpetual allegiance, together with some reasons drawn from the well-known feelings of mankind, have led courts to insist upon stronger facts and clearer evidence to establish a change to a foreign country than will be required to establish a change within a sovereign state. Says Kindersley, v.c., in Lord v. Colvin. Another principle is that which is referred to by Lord Cranworth in Wicker v. Hume in the House of Lords, namely, that it requires stronger and more conclusive evidence to justify the court in deciding that a man has acquired a new domicile in a foreign country, than would suffice to warrant the conclusion that he has acquired a new domicile in a country where he is not a foreigner. For instance, the court would more readily decide that a Scotchman had acquired a domicile in England than that he had acquired a domicile in France. Lord Cranworth's language is this: I think that all courts ought to look with the greatest suspicion and jealousy at any of these questions as to change of domicile into a foreign country. You may much more easily suppose that a person having originally been living in Scotland, a Scotchman, means permanently to quit it and come to England, or vice versa, than that he is quitting the United Kingdom in order to make his permanent home where he must forever be a foreigner, and in a country where there must always be those difficulties which arise from the complication that exists and the conflict between the duties that you owe to one country and the duties which you owe to the other. Circumstances may be so strong as to lead irresistibly to the inference that a person does mean quat enus in illo exuere patriam, but that is a presumption at which we ought not easily to arrive, more especially in modern times, when the facilities for travelling and the various inducements for pleasure, for curiosity, or for economy so frequently lead persons to make temporary residences out of their native country. Section 124. A change of domicile a serious matter, and presumed against, but in any case a change of domicile, whether domicile of origin or of choice, national or quasi-national, is a very serious matter, involving as it may, and as it frequently does, an entire change of personal law. The validity and construction of a man's testamentary acts and the disposition of his personal property in case of intestacy. His legitimacy in some cases and, if illegitimate, his capacity for legitimation, the rights and, in the view of some jurists, the capacities of married women, jurisdiction to grant divorces, and, according to the more recent English view, capacity to contract marriage. All these and very many other legal questions depend for their solution upon the principle of domicile, so that upon the determination of the question of domicile it may depend oftentimes whether a person is legitimate or illegitimate, married or single, testate or intestate, capable or incapable of doing a variety of acts and possessing a variety of rights. To the passage quoted in the last section Kindersley, v.c., adds, in truth, to hold that a man has acquired a domicile in a foreign country is a most serious matter, involving as it does the consequence that the validity or invalidity of his testamentary acts and the disposition of his personal property are to be governed by the laws of that foreign country. No doubt the evidence may be so strong and conclusive as to render such a decision unavoidable, but the consequences of such a decision may be, and generally are, so serious and so injurious to the welfare of families that it can only be justified by the clearest and most conclusive evidence. And the remarks of His Honour might be extended, although with somewhat diminished force, to small cases of quasi-national domicile, where the change sought to be established as between states or provinces under the same general government, but having different systems of private law, as for example between Scotland and England or between Pennsylvania and Louisiana. Thus Lord Curry-Hill, in Donaldson v. McClure, referring particularly to a change of domicile between England and Scotland, says, "The animus to abandon one domicile for another imports an intention not only to relinquish those peculiar rights, privileges, and immunities which the law and constitution of the domicile confers, in the domestic relations, in purchases and sales, and other business transactions, in political or municipal status, and in the daily affairs of common life, but also the laws by which succession to property is regulated after death. The abandonment or change of a domicile is therefore a proceeding of a very serious nature, and an intention to make such a change requires to be proved by very satisfactory evidence." Section 125. Change of domicile, a question of act and intention. All jurists agree that a change of domicile, of whatever grade, is a question of act, or fact, and intention, and cannot be accomplished without the concurrence of both. Pothier says, "Il faut pour cette translation la cause de la volonté du fait," and Denisot puts it thus, "Der choses sont nécessaires pour constituer le domicile, l'habitation réelle, et la volonté de la fixer au lieu l'on habite." Length of residence will not alone effect the change, intention alone will not do it, but the two taken together do constitute a change of domicile. The French Code provides, "Le changement de domicile s'opère par le fait d'une habitation réelle dans un autre lieu, joint à l'intention d'y fixer son principal établissement." In his report upon this article, the Tribune Maréchal says, "L'intention, qui n'est point accompagnée du fait, peut indique qu'on projette sans issue, le fait, qui n'est point accompagné de l'intention, peut indique qu'on essaie, qu'on déplacement passage, que l'établissement d'une maison secondaire." De Molimp draws an ingenious and interesting parallel between the acquisition of domicile and the establishment of possession. He says, "The principle is that domicile is formed by taking legal possession of the place in which one wishes to establish himself, and it is thus that the two most important rules of possession are found applicable to domicile. 1. Legal possession, civil possession, is acquired only by fact and intention united, corpore et animo, nec per se corpore, nec per se animo, by fact, that is to say, by occupation, by intention, that is to say, in general, by will to have the thing for one's own, to keep it not for a time, not precariously, as the hirer or the depository, but on the contrary to appropriate it in a manner permanent and durable, and here indeed is, as we shall see, the intention which particularly characterizes the establishment of domicile, this intention of the person who definitively adopts a certain place for the purpose of being the held and fixed. 2. Possession, once acquired, is preserved by intention alone, solo animo retentia. In the same way domicile also is preserved, as we have seen, distinct from and independent of residence. Section 126. Id. On the one hand, the mere fact of the transfer of bodily presence from one place to another will not work a change, and on the other, while mere intention is sufficient to retain a domicile already established, it is not sufficient to establish a new one, no matter how strong that intention may be or how solemnly expressed. Fact must concur with intention, otherwise no change takes place. Sir William Scott says, in The President, "A mere intention to remove has never been held sufficient, without some overt act, being merely an intention, residing secretly and undistinguishably in the breast of the party and liable to be revoked every hour." And he adds that even strong declarations of intention would not suffice. Paulus decided, domicilium re et facto transfertur, non nuda contestation. Case is a strong illustration of this principle. The petitioner, in insolvency, having determined to remove from New York, where he was domiciled, to Philadelphia and to reside there permanently, sent his wife and family to the latter city, but was himself detained in New York a month longer in the adjustment of his affairs. The court, remarking that no other weight could be attached to his sending his wife and children here except as a strong circumstance manifesting his intention to remove, dismissed the petition on the ground of want of jurisdiction, for which 6 months' residence was required. Almost identical with this case is the very recent case of Penfield v. the Chesapeake, etc. Company in the U.S. Circuit Court for the District of New York, in which the facts were that a resident of Street, Louis, Mo, having formed the intention of transferring his residence to Brooklyn, N.Y., in pursuance of that intention sent his wife and family to the latter city in August, 1883. Upon their arrival his wife hired a house there, in which she and her children thereafter continued to live. The plaintiff himself did not come to Brooklyn until January of the next year. Upon these facts the court held that he was not a resident of the state of New York prior to November 30, 1883, the question being one of limitation. Section 127. The requisite factum. Complete transfer of bodily presence. The requisite fact, or factum, is the transfer of bodily presence from the old place of abode to the new, and this factum must be complete. The factum must be not merely an inchoate act, not merely the first step towards the factum, but the completion of the factum by actual residence. The intention must be to leave the place where the party has acquired a domicile and to go to reside in some other place as the new place of domicile, or the place of new domicile, and the factum must be commensurate with it. Therefore it is that a new domicile cannot be acquired in itinere, except in cases of reverter, hereafter to be discussed. Section 128. Dictum of Sir John Leach in Monroe v. Douglas. A loose and obscure dictum of Sir John Leach in Monroe v. Douglas has given much trouble, and has misled several eminent jurists into stating doctrine in entire conflict with elementary principles and the great weight of the decided cases. His language is as follows: It is said that having afterwards quitted India in the intention never to return thither, he abandoned his acquired domicile, and that the forum origines revived. As to this point I can find no difference in principle between the original domicile and an acquired domicile, and such is clearly the understanding of Pothier in one of the passages which has been referred to. A domicile cannot be lost by mere abandonment. It is not to be defeated animo merely, but animo et facto, and necessarily remains until a subsequent domicile be acquired unless the party die in itinere toward an intended domicile. The qualification of death in itinere appears to be a singular one, and under all the circumstances it is hard to understand exactly what is meant by it. It was a mere dictum, apparently thrown in out of an abundance of caution, as a possible qualification of the general principle laid down, probably to cover the Scotch case of Colville v. Lauder, a case of reverter, which had been cited in argument. There were, however, no facts before His Honour to which the qualification could be applied, as it was clear from all the evidence and was assumed by the court that Dr. Monroe, whose domicile was in question, did not die in itinere toward an intended domicile, but while on a visit to his native land, Scotland, and it was held that his acquired domicile in India continued. The meaning of the Vice-Chancellor has been discussed at considerable length by Kindersley, V.C., in Lyall v. Patton and by other judges in other cases, and various conjectures have been started, but the obscurity still remains, and the case has been so much shaken by criticism as to be now of little, if of any, authority. Section 129. Wood, v. C., in Forbes v. Forbes, Wharton, Westlake, in Forbes v. Forbes, 1854, Wood, v. C., was, however, misled by it into laying down as a settled principle, that a new domicile cannot be acquired except by intention and act, animo et facto, and apparently if a man be in itinere it is a sufficient fact for this purpose. See Sir John Leach's judgment in Monroe v. Douglas. It will be observed that this dictum is much broader than that of Sir John Leach, who limited the doctrine to the case of one dying in itinere. Subsequently, However, in Udny v. Udny, 1869, Vice-Chancellor Wood, then Lord Chancellor Hatherley, seems to have recanted this doctrine, and indeed used language apparently wholly in conflict with it. Resting upon these dicta, a distinguished American law writer, Dr. Wharton, in his work on the conflict of laws, has fallen into the same error. He says, even when the point of destination is not reached, domicile may shift in itinerary if the abandonment of the old domicile and the setting out for the new are plainly shown. Mr. Westlake also, in the second edition of his work on private international law, in speaking of change from one domicile of choice to another, says, in the event of death in itinerary, the last domicile is the one toward which the person is journeying. Section 130. Domicile cannot be changed in itinerary, but notwithstanding these expressions of opinion by eminent jurists, the decided cases both in England and in this country appear to have overwhelmingly settled the doctrine precisely the other way, and the general rule, to which, however, reverter of domicile is an exception, is now thoroughly established, that domicile cannot be acquired in itinerary. Section 131. Id. In Lyall v. Patton, Lyall, the testator had a Scotch domicile of origin, but had acquired a domicile in India, and after residing there for upwards of 20 years he sailed from India in a vessel bound for an English port and died in itinerary. Kindersley, v.c., although deeming the evidence of his intention to settle in England insufficient, held that even if such had been his intention his Indian domicile would have adhered to him until his actual arrival in England. In a New York case, Graham v. the public administrator, the deceased having died at New York on her way from Scotland, her domicile of origin, to Canada, where she intended to settle, the court held that, not having reached her proposed home, and the rule that domicile can be acquired only animo et facto not having been satisfied, her Scotch domicile remained, and her estate was distributable according to the Scotch law. In Bell v. Kennedy, Lord Chelmsford says, it is necessary to bear in mind that a domicile, although intended to be abandoned, will continue until a new domicile is acquired, and that a new domicile is not acquired until there is not only a fixed intention of establishing a permanent residence in some other country, but until also this intention has been carried out by actual residence there. This language, although general, was, it is true, used in a case in which it was sought to set up a domicile of choice in derogation of the domicile of origin, but there is every reason to believe that American courts would apply it as well when the question was between two domiciles of choice. The British courts, however, might, in view of the adventitious character ascribed to acquired domicile in Udny v. Udny, in a case in which it became necessary to determine the domicile of a person during the transitus from an acquired domicile to an intended domicile, now decide that his domicile of origin had reverted. Section 132. Id. A fortiori, no change takes place when the territorial limits of the old domicile have not been passed. In the cases which have been so far referred to, the factum, although not complete, had progressed to the extent of removal of bodily presence from the seat of the former domicile. It follows, a fortiori, that no change can take place where a person has not yet passed the limits of the state or country of the domicile which he seeks to abandon, even though he has already commenced his journey, or is prevented from making it by circumstances beyond his control. This is true both as applied to questions of reverter and of the acquisition of domicile of choice. Thus in an early Pennsylvania case, left his former abode in Pennsylvania with the intention of settling in the then Spanish province of Louisiana, and while he was at Lancaster in that state, in itinerary, a foreign attachment was issued against him, which the court promptly quashed. In an English case, a widow whose domicile of origin was English, having acquired by marriage a French domicile, after the death of her husband embarked at Calais upon a steamer bound for England, with the intention of going to that country to reside permanently there, but before the vessel left, becoming ill, she was obliged to Ireland and soon afterwards died in France. Upon these facts Sir C. Cresswell held that her acquired domicile remained, there being no sufficient abandonment so long as she remained within the territory of France. Section 133. Id. Residence in a definite locality not necessary. It is probably not necessary that, in order to work a change of domicile from one state or country to another, the person whose domicile is in question should reach the particular spot within the territorial limits of the latter at which he intends fixing his permanent abode, and indeed it may perhaps be said that it is not absolutely necessary for such purpose that the person should ever have, either in fact or in contemplation, a permanent home within any particular municipal division of such state or country. Such cases must necessarily be rare, but it is possible to conceive of a Frenchman, for example, coming to England with the intention of permanently remaining there, but without ever fixing a permanent abode in any particular part of that country. In such case, while it would doubtless be much more difficult to prove the requisite intention than if he had, for example, purchased a dwelling house and fixed himself in it in an apparently permanent manner, yet, assuming the requisite intention to be made out by other proofs, there is little doubt that his domicile would be held to be changed. Lord Jeffrey, in Arnott v. Groom, thus remarks upon this subject: "I cannot admit, what Lord Fullerton assumes to be the rule, that in order to make a domicile it is necessary to have some particular spot within the territory of a law, that it is not enough that the party shall have an apparently continual residence there, but shall actually have a particular spot or remain fixed in some permanent establishment. In considering the indicio of domicile, these things are important, but they are not necessary, as matters of general law, to constitute domicile. Many old bachelors never have a house they can call their own. They go from hotel to hotel, and from watering place to watering place, careless of the comfort of more permanent residence, and unwilling to submit to the gene attendant on it. There was the case of a nobleman who always lived at inns, and would have no servants but waiters, but he did not lose his domicile on that account. If the purpose of remaining in the territory be clearly proved a later, a particular home is not necessary. Dicey also maintains the same view. Section 134. Id. No length of residence necessary to constitute domicile. When the transfer of bodily presence has been accomplished, the factum is complete, and generally speaking, no further act is necessary, but domicile vests immediately, provided the requisite animus be present. Uno solo die constituitur domicilium si de voluntate parit, says de Argenta, and Grotius puts it still more strongly, uno momento domicilium constitutum intelligitur. Formerly in Germany domicile could be acquired only by residence for a year, and this was so, too, according to the custom of Paris, but Denisot lays it down that un jureden meilleur dans un lieu, avec intention d'y fixer un domicile, suffit pour la table. It was sought to incorporate in the French code a provision requiring residence for a certain length of time to establish domicile, but this was deemed unwise and the proposition was rejected. Section 135. Intention necessary. Length of residence not sufficient in the absence of intention. But if the proper factum is absolutely essential to the constitution of a domicile of choice, certainly the proper animus is not less so. Hence mere change of residence, however long continued, is not sufficient unless the proper animus be present. This, too, is an almost undisputed rule. Says Donellus, habitatio non est satis, animum consistendi excedere portet. Quisquis temporis causa alicubi comerator et consistit, ibi domicilium non habet, ans angelus, ex sola autem domus in habitation, valera omrium, immobilium silicit, in aliena civitator trigens et territorio comparatarum et acquisitarum posses sun domicilium non probata, nec constituitur, stex animo et voluntate alicubi domicilium habendi. Non enim exeo, quod quis focum et ignum tenit, arguitur domicilii constitutio, ut pot, que ex solo animo perpetuo habitandi in loco dependit. And Corvinus, nec etam sola habitatio per se, etam si sit longissimi temporis, domicilium constituit. And Denisot, por se fixa un domicile, il faut qu'il y ait un choix manifeste par un volonté express. Quelques long case while habitation dans un lieu, elle ne constitue pas de domicile, si on n'a pas en l'intention de l'y établir. Nulla tempora constituant domicilium allet cogitanti, says de Argenta, and Mascidus tells us, on the authority of Bartellus, Baldus, Solistus and others, that 1,000 years would not suffice, and his statement is repeated with approbation by Corvinus. John Voet, in his commentaries on the Pandects, says, Illud certum est, nec solo animo ad qui destination patris familias, aut contestation sola, sine re et facto, domicilium constitui, nec sola domus comparation in aliqua region, nec sola habitation, sine proposito illic perpetua mirandi, cum alpinus a domicilio habitationum distinguat demercerit, legem Cornelium injuriarum de doma vi introita, ad omnem habitationum inque pater familias habitat, licet ibi domicilium non habet, pertinia. This distinction between habitatio and domicilium is the familiar one between residence and domicile, the latter being residence coupled with the intention to settle permanently. Section 136. Id. In the American case of White v. Brown, the jury found that absence for 48 years did not destroy domicile, and the court affirmed their finding. In England it was held, in Capdevel's case, that residence for 29 years worked no change, so in Jopp v. Wood 25 years, and in Hodgson v. Dobson 23 years, residence was considered insufficient. In Bremer v. Freeman, Sir John Dodson said that a person may live 50 years in a place and not acquire a domicile, for he may have had all the time an intention to return to his own country. Residence of itself, although decisive of the factum necessary for a change of domicile, is decisive of nothing further, and even when long continued, although per se evidence of intention, will not supply its place. Residence is of little value if not united to intention, and is nothing if contradicted by it. Intention must concur with fact, and must clearly appear. On the one hand, the shortest residence is sufficient if the requisite animus be present, and on the other the longest will not suffice if it be absent. Section 137. Character of the animus or intention. Capacity to choose. But intention implies three things: 1. Capacity to choose, 2. Freedom of choice, and 3. Actual choice. In order to set up a domicile of choice there must be, first, capacity to choose. Therefore it is that one who is not sui juris is deemed in law incapable of acquiring a domicile for himself. Thus, at birth an infant, if legitimate, takes as his domicile of origin the domicile of his father at the time of his birth, and acquires no other during infancy except through the act of his father, or if he be dead, through the act of his mother, so long, at least, as she remains a widow. In like manner an illegitimate or posthumous child takes as his domicile of origin the domicile of his mother, and acquires no other during infancy except through the act of his mother, so long, at least, as she remains single. So, too, a married woman upon marriage takes as her domicile the domicile of her husband, and, speaking generally, is incapacitated during coverture from acquiring any other by her own act. Idiots and lunatics furnish further illustration of the principle. All of these persons are conclusively presumed in law to be wanting in capacity to form the intention requisite for a change of domicile, and therefore depend for such change upon others who are in law capable of forming such intention. Section 138. Id. Freedom of choice. Compulsory change of bodily presence. Second, there must be freedom of choice. A compulsory change of bodily presence is not a change of domicile. Thus a soldier, according to the English and American cases, does not necessarily become domiciled at the place where he is stationed, although, by a confusion of the ideas of allegiance and domicile, he is in most cases conclusively presumed to be domiciled within the country in whose service he is employed. This, however, does not conflict with the principle above stated, as, generally speaking, a man enters the service of a foreign country only through choice, nor does it conflict with the right of the soldier to change his quasi-national domicile. A prisoner does not necessarily become domiciled at the place where he is imprisoned, nor a pauper where he is kept at an almshouse. The exile escaping from political persecution, the fugitive from justice, and, according to the opinion of a great English judge, the one who, harassed by debts, flees to avoid his creditors, all fall within the same category. Their absence from the old place of abode, at least, if not their presence in the new, is a matter of necessity and not of choice, of compulsion and not of intention, and therefore no change of domicile ensues. Section 139. Id. Inability to return. Moreover, it is immaterial whether a person has been driven from his former place of domicile and prevented from returning by causes existing there, or whether he has voluntarily left it intending to return, and is prevented from carrying out his intention by irresistible causes existing elsewhere. In neither case is his domicile changed, because in both his continued absence is involuntary. Thus in an Alabama case, in which the facts were that a minor left his parents in Germany, and, coming to that state, always declared his intention of returning home upon the attainment of his majority, but was prevented from so doing by the outbreak of the rebellion and the blockade, it was held that he had acquired no domicile and was not subject to military service in the Confederate Army. So, too, in an Iowa case, in which the facts were that a person domiciled in that state went in 1860 to Texas on a visit to her daughter, and to collect a debt from the estate of a deceased relative, but the rebellion breaking out she was detained there, and during her absence suits were brought against her in Iowa, and process was served by leaving copies at her former usual dwelling place. It was held that the service was good, and the subsequent proceedings and sale of real estate based thereon were valid, the defendant never having relinquished her animus revertendi. Sir William Scott went even a step further in the case of the Ocean, and held that a British-born subject who had settled as a partner in a house of trade in Holland, but upon the breaking out of war had made every arrangement for a dissolution of the partnership and a return to England, and was only prevented from removing by the forcible detention of all British subjects, had regained his British national character. This, however, was a prize case, and would probably not be followed as a precedent in any case not involving the question of national character in time of war. Indeed, the opposite view was held by Sir Cresswell in Goods of Raffenel. Section 140. Id. Compulsion and Motive. A distinction must be noted between compulsion and a mere motive inducing one to change his place of residence. Thus the fact that residence is in deference to the wishes of another does not prevent domicile from attaching. This was early laid down by Lord Alvanley in Somerville v. Somerville. It is said his father's dying injunctions were that he should not dissolve his connection with Scotland. In the subsequent part of his life he most religiously adhered to those injunctions, but it is said that in conversation he manifested his preference of England, that if it had not been for those injunctions of his father, he would have quitted Scotland. Admit it. That in my opinion is the strongest argument in favour of Scotland, for whether willingly or reluctantly, whether from piety or from choice, it is enough to say he determined to keep up his connection with that country, and the motive makes not the least difference. So in Aitchison v. Dixon it was held by James v. C. that the fact that the residence of a Scotchman in England was out of deference to the wishes of his wife, who was an English woman of wealth, and who provided a home for her husband and exercised great influence over him, rather strengthened than otherwise the inference of domicile there. On the other hand, in Hodgson v. Dobson, the Judicial Committee of the Privy Council, speaking through Dr. Lushington, held that the residence of General Hodgson in Paris for a long period, 23 years, was rendered less important, as evidence of his intention, by the fact that his residence there was in deference to the wishes of his wife, who was a French woman. These cases, however, are easily reconcilable upon their circumstances, and merely go to establish that residence, as evidence of intention, may, according to circumstances, be either weakened or strengthened by the fact that it is in deference to the wishes of another. Except as in evidence of intention, motive is immaterial so long as the individual remains free to choose, but whenever the controlling influence becomes a vis major which shuts out the operation of choice, speaking generally at least, a change of domicile becomes impossible. Section 141. Id. The distinction between compulsion and motive has been further illustrated by the case of an invalid, the domicile of one who flies from the rapid approach of death to a more congenial climate, or of one who being abroad on account of ill health finally surrenders all hope of return, undergoes no change thereby, but where a preference for a particular climate operates merely as a motive inducing one to change his place of abode, a change of domicile is no more prevented thereby than by a preference for a place on account of the manners and customs of the inhabitants, or the superior business facilities which it affords. It must be conceded, however, that the distinction between motive and compulsion may become very shadowy, and in some cases hard to apply. It may become impossible to determine just where motive ends and compulsion begins, inasmuch as motive may, and frequently does, rise to the degree of strong moral compulsion, which shuts out practically, though not absolutely, the operation of choice. A sharp dividing line certainly cannot be drawn, but as we approach the middle ground each case must be determined upon its own peculiar circumstances. Section 142, id. Motive immaterial if the proper intention exist. And here another view of motive must be noticed. It is admirably stated by Morton, C.J., in a late Massachusetts case, as follows: a man has the right to change his domicile for any reason satisfactory to himself. In determining whether there has been such a change from one place to another, the test is to inquire whether he has in fact removed his home to the latter place with the intention of making it his residence, with the proper animus manendi. If he has, he loses his old domicile and acquires a new one with all its rights and incidents, and the law does not inquire into the purposes or motives which induced him to make such change. It may be because he prefers the laws of the new place of domicile, or because he can diminish his taxes and other burdens, or because he desires to bring a suit in a court which would not otherwise have jurisdiction. His status as an inhabitant depends upon the fact that he has made a change of his home, and not upon the motives or reasons which influenced him to do so. In the case at bar, therefore, it being found as a fact that the respondent, Kelly, had become a resident of this state, he had the right to apply for the benefit of the insolvent laws, although his sole purpose in making the change was to enable himself to do so. In Briggs v. French, Story, J. says, it is every day's practice for a citizen of one state to remove to another state to become a citizen of the latter in order to enable him to prosecute suits in the courts of the United States. And provided the removal be real and not merely nominal, and he has truly become a citizen of another state, I have never understood that his motive would defeat his right to sue. It might be a circumstance to call in question the bona fides and reality of the removal or change of domicile. But if the new citizenship is really and truly acquired, his right to sue is a legitimate, constitutional, and legal consequence, not to be impeached by the motive of his removal. Section 143, id. Actual choice. Third, there must be actual choice. In order to effect a change of domicile, a person must not only be capable of forming the proper intention and free to do so, but he must actually form such intention. This point has already been treated of. Absence from a place of domicile and presence in another place if long continued is often strong evidence of a change, but it does not of itself constitute a change if the requisite animus be not present. Some cases upon this point have been alluded to. The subject may be further illustrated by the case of an ambassador, consul, or other person abroad in the civil service. There is nothing in the official character of such person which prevents him from acquiring domicile where he resides, but even when the residence is long continued, the presumption of law founded upon the usual course of affairs, and therefore subject to rebuttal, is that he is abroad for a temporary purpose, subject momentarily to recall, and hence has not chosen his present abiding place as a place of permanent abode. Section 144, id. Requisite animus, not intention to change political nationality. What then is the requisite animus? First, it is not, in cases of national domicile, intention to change nationality. Allegiance and domicile are entirely distinct things. They may exist apart, they may exist together, but the one does not necessarily involve the other. Thus a man may be at the same time a British subject and a domiciled American. Lord Westbury, in Udney v. Udney, thus states the distinction: the law of England and of almost all civilized countries ascribes to each individual at his birth two distinct legal states or conditions, one by virtue of which he becomes the subject of some particular country, binding him by the tie of natural allegiance, and which may be called his political status, another by virtue of which he has ascribed to him the character of a citizen of some particular country, and as such is possessed of certain municipal rights and subject to certain obligations, which latter character is the civil status, or condition of the individual, and may be quite different from his political status. The political status may depend upon different laws in different countries, whereas the civil status is governed universally by one single principle, namely, that of domicile, which is the criterion established by the law for the purpose of determining civil status. Formerly British statesmen and jurists clung with great tenacity to the doctrine of the indelibility of natural allegiance, applying sometimes with great rigour the maxim, nemo potest exuere patriam, until in 1870 they yielded to more enlightened and modern views of international relations, and both by treaty with the United States and by statute totally and finally surrendered the doctrine. But long before that step was taken, changes of national domicile were held in English and Scotch cases. It was indeed doubted by Sir John Nicol, in Curling v. Thornton, whether a man could so far exuere patriam as to accomplish a change of national domicile for testamentary purposes, but his Honour's doubts were expressly overruled by the High Court of Delegates in the subsequent case of Stanley v. Bunnies, and it was settled that a person might accomplish such change at pleasure. In America, too, it was formerly held that a person could not entirely rid himself of his natural allegiance, but it has never been doubted that one might change his domicile at pleasure. Section 145. Id. Morehouse v. Lord. The distinction has of late been brought into greater prominence by the criticisms which have been passed upon certain unfortunate expressions which fell from Lords Cranworth and Kingsdown in the case of Morehouse v. Lord. The language of the former was as follows: in order to acquire a new domicile, a man must intend quat annus in illo exuere patriam. It is not enough that you merely mean to take another house in some other place, and that on account of your health, or for some other reason, you think it tolerably certain that you had better remain there all the days of your life. That does not signify. You do not lose your domicile of origin or your assumed domicile merely because you go to some other place that suits your health better, unless, indeed, you mean, either on account of your health or for some other motive, to cease to be a Scotchman and become an Englishman or a Frenchman or a German. In that case, if you give up everything you left behind you and establish yourself elsewhere, you may change your domicile. The expression used by Lord Kingsdown was to the same effect. The language thus used was not necessary to a decision of the case, but advantage was taken of the occasion to enunciate what Lord Cranworth denominated some modern improved views of domicile. The expressions of their lordships have been much criticised and perhaps to some extent misunderstood. Thus Branwell, B., in Recap Devel, says, the expressions used appear to me, with great deference, far too extensive. To say that a man cannot abandon his domicile of origin without doing all that in him lies to divest himself of his country, is a proposition which, with great submission, I think cannot be maintained. In the ordinary case of the Irish or English labourer emigrating to the United States of America without any hope or intention of ever returning, but not naturalizing himself for fear of being subject to conscription, ready to claim the protection of the British ambassador to prevent his being made a conscript, but having no desire or intention whatever to remain a British subject, I think that if he died in America it could scarcely be argued that America was not his place of domicile, although he had not done all that in him lay to abandon his native country. Therefore, assuming those noble and learned lords intended to overrule previous cases, I have great difficulty in supposing that they intended everything that would be comprehended within the very extensive expressions they used. Referring to Lord Kingsdown's expression, also used by Lord Cranworth, in Morehouse v. Lord, that a man must intend to become a Frenchman instead of an Englishman, Lord Westbury said, in Udney v. Udney, these words are likely to mislead if they were intended to signify that for a change of domicile there must be a change of nationality, that is, of natural allegiance. That would be to confound the political and civil status of an individual, and to destroy the difference between patria or domicilium. Section 146. Id. But that Lords Cranworth and Kingsdown could not have meant that a change of national domicile involved a change of nationality in the sense in which Lord Westbury uses the term, is clear from the fact that the case of Morehouse v. Lord was decided in 1863, and the doctrine of perpetual allegiance was not surrendered by Great Britain until 1870. The context shows that the strong expressions which they used were merely meant to convey the idea of a person incorporating himself as a permanent settler in another country, although Wickens, v. C. understood them to mean that intention to change civil status was necessary. Section 147. Id. In the late case of Brunno v. Brunel, decided since the Naturalization Act, the exact question arose, and notwithstanding that the deceased had distinctly declared that he would not give up his French citizenship, and had declined to become a naturalized British subject, it was held by Bacon, v.c., that he had become a domiciled Englishman. The Vice-Chancellor in that case used this language: to effect a change of domicile it is not necessary to obtain letters of naturalization. A permanent residence by a foreigner in this country with no intention of ever returning to his native country will be sufficient to create a domicile in this country. Udney v. Udney cuts down, or rather explains, the expressions in Morehouse v. Lord, that for a change of national domicile there must be a definite and effectual change of nationality, that a man must intend exuere patriam, and I adopt what was said by Lord Westbury. It must be said, however, that a change of allegiance accompanying or following a change of residence would be very strong evidence of intention to change domicile. Section 148. Id. Or civil status. Second, the requisite animus is not intention to change civil status. A change of civil status is, as has already been pointed out, one of the legal consequences of a change of national or quasi-national domicile, but it is a consequence which rarely presents itself to the mind of one contemplating a change of domicile. To hold, therefore, that in order to accomplish a change of domicile a man must have present in his mind, and must deliberately accept the notion of a change of civil status, would be practically to declare that a change of domicile rarely or never takes place, a convenient rule, perhaps, as Wickens, v.c., points out, for courts to work by, but one entirely at variance with general principles, and, although supported by opinions of great weight, with almost all of the decided cases. In Douglas v. Douglas, the learned judge named uses this language: it is universally, or all but universally, true, that in order to prove that the domicile of an adult of sound mind has been changed an intention on his part must be shown. The question on which opinions have differed is as to what he must be shown to have intended. According to one view it is sufficient to show that he intended to settle in a new country, to establish his principal or sole and permanent home there, though the legal consequences of so doing on his civil status may never have entered his mind. According to the other view it is necessary to show that he intended to change his civil status, to give up his position as, for purposes of civil status, a citizen of one country, and to assume a position as, for the like purposes, the citizen of another. This stricter view is supported by opinions of great weight, among others by the Lord President in Donaldson v. McClure, that of the Lord Chief Baron Pollock, in Attorney General v. Countess de Walstadt, and by some expressions used by the late Lords Cranworth and Kingsdown. And it would be an extremely convenient one since, if, for the purpose of showing that a man had changed his domicile, it were necessary to show that the notion of a change of the civil status had occurred to his mind and been accepted by his will, the attempt would in most cases fail. Few men think of or wish for a change of civil domicile as such, except perhaps in certain cases where a man desiring to change his political domicile contemplates the change of civil domicile as involved in it, and occasionally where the object of the change is to escape into a freer condition of marriage law. And cases like Haldane v. Eckford, where the change of civil status can be shown to have been recognized and accepted by a person who had no special reason to desire it, and probably did not desire it, are very rare indeed. The stricter rule would therefore, in the great majority of cases, leave the domicile to be governed by origin, which it seems to me would be in every respect a convenient view. In this case, if I considered the strict rule as law, I should have no difficulty whatever in holding that the testator never changed his domicile. I feel sure that the idea of changing his civil status from that of a Scotchman, under the Scotch law, to that of an Englishman, under the English law, never occurred to him, and that if it had occurred to him he would have repudiated it. Probably the question as to his eldest son's legitimacy would of itself have been conclusive on this point. But I cannot satisfy myself that the stricter rule, as I have called it, can be considered as the law of England. It never was, I believe, the law of any other country, except perhaps Scotland, or recognized as law by any of the text writers of European authority who have dealt with questions of domicile, and it is difficult to believe that the law of England has drifted so far from the general principles on which it professed to be founded and which it always professed to follow. It seems to me, as it did to Vice-Chancellor James, in Haldane v. Eckford, that the intention required for a change of domicile, as distinguished from the act embodying it, is an intention to settle in a new country as a permanent home, and that if this intention exists and is sufficiently carried into effect, certain legal consequences follow from it, whether such consequences were intended or not, and perhaps even though the person in question may have intended the exact contrary. The case of a person wishing to settle permanently in a country different from that of his domicile, but to retain, as regards testamentary and matrimonial matters, and as regards civil status generally, the law of the country that he leaves, may have rarely arisen, and is perhaps not likely to arise. When it arises, if it ever should arise, the determination ought, I think, to be that the intention was sufficient to warrant a conclusion in favor of a change of domicile. Section 149. Id. In Steer's case, the testator, whose domicile of origin was English, and who had resided upwards of 40 years at Hamburg under circumstances which plainly showed his intention of permanent residence there, made a will in England which contained the following declaration: whereas, although I am now in England, my residence recently was in Hamburg, of which for the purpose of enabling me to trade I was constituted a burgher, and my intention is to return there, but I do not mean by such declaration of intention to renounce my domicile of origin as an Englishman. But in spite of this the Court of Exchequer held that he was domiciled in Hamburg and not in England. We have already seen that a person may have in view, in settling in a new territory, the subjection of himself to the peculiar laws of that territory, but it by no means follows that he must have such purpose in view. Furthermore, while the opinion of the person whose domicile is in question as to whether a change has been effected or not, may be some evidence of his intention, it is of little value if contradicted by the facts and circumstances attending his residence. Section 150. The requisite animus defined. The intention requisite for a change of domicile is, 1. Intention completely to abandon the former place of abode as a place of abode, and, 2. To settle presently and permanently in another place. The subject naturally divides itself into the animus non revertendi and the animus manendi, which it is proposed to consider separately. Section 151. 1. Animus non revertendi. It results from the maxim, no person can have more than one domicile at the same time, that before a new domicile can be established the old one must be abandoned, and as the presumption of law is always against a change of a domicile, abandonment must clearly appear, and the onus is upon him who asserts it. This burden is not discharged by merely showing absence, although for a long period. If the absence is such as is not inconsistent with an intention to return, the former domicile is retained, and a fortiori it is retained where animus revertendi affirmatively appears. The fundamental idea of domicile is home, and as a man does not lose his home in fact by mere absence, so he cannot lose his home in law from the same cause. Indeed, nothing is better settled than that absence for a temporary purpose cum anima revertendi is not sufficient to work a change of domicile, and it makes no difference whether such absence is for business, pleasure, health, or personal security, nor to what length of time it is prolonged, intention to return at a future time, however remote, being sufficient to retain domicile. Sailors absent on long voyages, soldiers or ambassadors absent in the service of their sovereign, and fugitives from political persecution, are examples of the application of the principle. They are presumed to retain their former domicile because their absence is not inconsistent with intention to return. Section 152. Animus non revertendi. Mere absence does not destroy domicile. In Aikman v. Aikman, absence for 47 years, a part of which time was spent in the maritime service and a part in the pursuit of an illicit connection, was held not to have worked a change of domicile in the absence of proof of animus non revertendi. In de Bonneville v. de Bonneville, a refugee from the French Revolution, was held to have retained his French domicile notwithstanding residence of 20 years in England, intention to return to France being presumed from the circumstances attending his departure. In Hodgson v. Dobson, an Englishman was held to have retained his English domicile after a residence of 23 years in France, the circumstances attending it not being deemed sufficient to warrant the inference of animus non revertendi. In Jopp v. Wood, a Scotchman resident in India 25 years in business was held not to have lost his Scotch domicile, as it appeared that he intended to return to his native country after acquiring a fortune in India. In Capdevil's case, a Frenchman was held to have retained his French domicile after an absence in trade of 29 years, and in White v. Brown, an American was held not to have lost his domicile by 48 years' absence for business and pleasure. And so instances might be multiplied indefinitely. It is true that in almost all of the cases cited the absence was broken by occasional returns, but as will be seen hereafter, occasional returns will not of themselves retain domicile. Section 153. Id. Abandonment not a mere matter of sentiment. As to the nature of abandonment, and the extent to which one must intend to break away from his former place of abode, there has been some difference of opinion. Abandonment is certainly not merely a matter of sentiment, a strong regret at being compelled to give up one's former place of abode, a panting for one's native home, a yearning of the untravelled heart, a lurking desire to return, or a vague and uncertain intention to do so depending upon some distant and improbable contingency, is not inconsistent with it. In Haldane v. Eckford, the evidence showed that the testator retained the deepest affection for his native country, Scotland, its people and everything pertaining to it, which he manifested on all occasions and in the most touching ways, that he had a great longing to return, and desired to buy land there. Yet as his intention of permanently residing in Jersey clearly appeared, a change of domicile was held. Such feelings, although they sometimes throw light upon the intention of the person whose domicile is in question, are generally too impalpable for courts to deal with. But exactly where the line is to be drawn to separate the feeling or intention which will not prevent a change of domicile from the intention which will, it is very difficult to say. Section 154. Id. Floating intention to return. Story's proposition. Story, in his work on the conflict of laws, has made use of a phrase which has given rise to some criticism and difficulty. He says that if a person has actually removed to another place with an intention of remaining there for an indefinite time, and as a place of fixed present domicile, it is to be deemed his place of domicile, notwithstanding he may entertain a floating intention to return at some future period. But the inquiry immediately suggests itself, what is meant by a floating intention? Certainly not that the period for the return is simply indefinite and as yet unfixed, for then the proposition would be in conflict with almost every case in which a change of domicile has been decided against, and would entirely destroy the distinction between temporary and permanent absence. If it means a vague, unsettled, flickering inclination, a lurking desire, or the like, thus much of the proposition at least would not be disputed. If, however, it means that the question of return is to be determined by the happening or not happening of some future event which is looked forward to, it requires some discussion and more explicit statement. Section 155. Id. Examination of the authorities upon which Story's proposition was based. The proposition was predicated upon the cases of Bruce and Stanley v. Bunnies. In the latter case the testator, an Irish Protestant by birth, went to Lisbon in 1770, and there established himself in business as a merchant. He soon afterwards married a lady who, though of Irish parentage, was a Portuguese subject by birth, and in order to contract that marriage, he professed the Roman Catholic religion. In 1798 he obtained letters of naturalization as a Portuguese subject, which letters declared that he had given satisfactory proof of his intention to reside for life in the Kingdom of Portugal, and in fact he did reside within its territories for 56 years, until his death in 1826. On the other hand, during the later years of his life, he appears to have frequently expressed an earnest wish and intention to return to end his days in Ireland, and to have done certain acts which might be looked upon as evidence of animus revertendi. But this floating intention appears to have been formed after his acquired domicile had vested, and the case therefore cannot be considered as an authority for the proposition referred to. The case of Bruce v. Bruce was different. It was the first of that class of cases known as the Anglo-Indian cases, in which it was held that one who went out to India from England or Scotland, in the service of the East India Company, for the purpose of making a fortune, thereby gained an Indian domicile, although there existed the ulterior intention of returning, when his object was accomplished, to his native land there to end his days, a contingency which was not only not unlikely to happen, but which in fact was frequently fulfilled. It will be observed that this doctrine is in conflict with the most approved definitions of domicile, and particularly with that given with approbation by Story himself from Putnam v. Johnson, namely, the habitation fixed in any place without any present intention of removing therefrom is domicile. As the circumstances which gave rise to these cases and the doctrine contained in them have passed away, a detailed examination of them here would be without profit. It is sufficient to say that they gave rise to much discussion, and for many years continued to puzzle English jurists who sought to harmonize them with the general principles of domicile, until they were finally put upon what seems to be their proper ground, and is certainly a plausible ground, namely, that the East India Company was a quasi-foreign government, and that persons entering its service must be presumed to be domiciled within its jurisdiction. The doctrine of these cases, as originally and in the time of Story, understood, has therefore been discarded in England, and has been pronounced by Kindersley, v.c., anomalous, and an excrescence upon any principle as to domicile. Accordingly, it has been decided that one who left England and went to India for the purpose of making his fortune in private business, intending finally to return, did not lose his English domicile, although he remained in India 25 years and died there. And such was the doctrine of the Dutch jurists even with regard to persons who went to India in the service of the Dutch East India Company. Thus it was held by a high authority, Groningen, that a person whose domicile was at Delft, having, with a view to make his fortune, gone to the East Indies in the service of that company, and died there, was at the time of his death domiciled at Delft. Such too was the opinion of John Voet. Section 156. Id. Near and remote contingency. Lord Campbell in Aikman v. Aikman. In Aikman v. Aikman, Lord Chancellor Campbell draws the distinction between a near and a remote contingency, remarking that if a man is settled in a foreign country in some permanent pursuit requiring his residence there, a mere intention to return to his native country on a doubtful contingency will not prevent such residence in a foreign country from putting an end to his domicile of origin. But a residence in a foreign country for pleasure, lawful or illicit, which residence may be changed at any moment without the violation of any contract or any duty, and is accompanied by an intention of going back to reside in the place of birth on the happening of an event which in the course of nature must speedily happen, cannot be considered as indicating the purpose to live and die abroad. And the same is doubtless true with regard to residence for purposes of business, if the event looked forward to, upon which the return depends, is likely to happen and to happen soon. It probably makes little difference whether residence is for pleasure or business. The remarks of Lord Campbell are made with reference to a change from the country of origin to a foreign country, but they would probably apply with equal force where the question was one of abandonment of an acquired domicile. Section 157. Id. Craigie v. Lewin. The distinction is illustrated by some of the East India cases. In Craigie v. Lewin, Lieutenant Colonel Craigie, a Scotchman by birth, at an early age entered the East India military service, and in 1837, having attained the rank of lieutenant colonel, came to Scotland on leave of absence for 3 years, which could however be renewed for 2 years longer. It was evident from all the circumstances that he desired to settle permanently in Scotland, but unless he attained the rank of colonel he was liable at the expiration of his leave of absence to be called back to India. As he had long been in the service of the company, it was probable, though by no means certain, that he would attain that rank before his leave expired. He died, however, in 1840, before the expiration of his leave, and before he had attained the rank of colonel. It was held by Sir Herbert Jenner Fust, that he retained his Anglo-Indian domicile. On the other hand, after attaining the regimental rank of colonel, the military servants of the East India Company might reside abroad for an unlimited time, subject to recall only in cases of extreme emergency, which appear rarely to have happened. Such remote possibility of return has not been considered by the English courts sufficient to prevent a change of domicile. Section 158. Id. Although the distinction between a near and a remote contingency seems to be a safe enough one, if properly applied, it is difficult to say how far it would be recognised now in England in view of the later cases. Lord Wensleydale, in Aikman v. Aikman, observed, "Every man's domicile of origin must be presumed to continue until he has acquired another sole domicile by actual residence with intention of abandoning his domicile of origin. This change must be animo et facto, and the burthen of proof unquestionably rests upon the party who asserts the change." This proposition is only a repetition in somewhat different phrase of the third rule of Lord Alvanley in Somerville v. Somerville, but it seems henceforth to have attracted greater attention. It has been frequently repeated in the later cases, and seems to have been understood as shutting out all animus revertendi. In Capdevel's case, it was held by Martin and Channell, b. to be entirely in conflict with Storius' proposition given above. In Wicker v. Human Morehouse v. Lord, very strong expressions were used, that a man must intend quatenus in illo exuere patram, must mean to cease to be a Scotchman and become an Englishman or a Frenchman, etc. In short, that he must do everything in his power to rid himself of his connection with his former domicile. In the latter case Lord Chelmsford declared his opinion that a change of domicile could not take place if any event, certain or uncertain, which might induce a subsequent change of residence were looked forward to. It will be observed that all the cases above referred to, except Wicker v. Hume, were cases in which an abandonment of domicile of origin was sought to be shown, but if the principles are correct, they are also applicable, though with somewhat diminished force, to the abandonment of acquired domicile. It may therefore be possible to conceive a floating intention so vague and impalpable as to be able to run the gauntlet of the recent English decisions, but the contingency upon which it depends would have to be extremely remote, or the intention itself of a very shadowy character. It is true that in Udny v. Udny and its sequence, the extreme expressions used in Wicker v. Human Morehouse v. Lord are criticised, and the doctrine of those cases is somewhat modified, but there is every reason to believe that the English courts would not now hold a change of domicile, particularly to a foreign country, without the strongest and most unequivocal proof that the former place of abode had been completely and finally abandoned as a place of abode. In Brunno v. Brunel, the deceased had declared that he might return to France, but all the indicia of animus manendi were so strong as to show that the animus revertendi, if entertained at all, was very vague, and a change of domicile was held. Section 159. Story's proposition in the American cases. In America, Story's proposition has been received, and is quoted and approved in many cases, without however any special attempt having been made to get at its meaning. Some confusion has been introduced in several cases involving the question of abandonment of quasi-national domicile, in which it is held that if the intention be to return at a future indefinite time it is not sufficient to prevent a change, thus breaking down the distinction between temporary and permanent absence. This doctrine is however confined to a few cases, and appears to have crept in from the cases of municipal domicile. But the great weight of the best considered American cases seems to be that no change can occur where there is an intention to return, unless that intention be very vague or depend upon a remote contingency. Our courts, however, have not used language so strong as that of some of the late English cases. Section 160. Occasional visits to, and retention of dwelling house at, former place of abode. The former place of abode must be abandoned only as a place of abode. Therefore occasional returns, or an intention to return for temporary purposes of business, or pleasure, to remove one's family, or the like, will not prevent a change of domicile. The mere retention of landed estate at the former place of abode is certainly not inconsistent with abandonment, but whether the retention of a place of residence, a furnished house or the like in which the person may, and probably does intend to, reside occasionally, is or is not consistent with abandonment, has been the subject of some difference of opinion in Aikman v. Aikman, Lord Campbell, and in Maxwell v. McClure, Lords Campbell and Cranworth, while admitting that the retention of such residence at the place of acquired domicile was a very cogent circumstance to show that the party did not intend to change his domicile, were of opinion that it would not be a bar to reverter of domicile of origin. On the other hand, Lord Wensleydale in the latter case declared himself unable to conceive a case in which a change of domicile could take place under such circumstances. In Forbes v. Forbes, Wood v. C. inclined to the opinion that the retention of such residence was not inconsistent with abandonment of a resumed domicile of origin in favor of a third place. Section 161. Animus non revertendi need not be express or conscious. Abandonment may be either express or implied, that is to say, a person may, a, upon leaving the place of his domicile, or afterwards, expressly and definitively determine not to return to it, and this may happen whether or not he selects a new place of abode, or, b, he may settle in a new place in a manner so permanent and exclusive as to be entirely incompatible with an intention to return, although he may never have consciously formed any resolution upon that particular point. In other words, animus non revertendi may be implied in animus manendi, but when the latter is relied upon to prove the former, the inference must be clear and unequivocal. Section 162. 2. Animus manendi. But the animus non revertendi is only one side of the animus which is required for the establishment of domicile of choice. When a person has abandoned his former place of abode, that is, has left it cum animo non revertendi, and has accomplished the factum of a change of bodily presence to another place in order to establish a domicile there, one further element is necessary, namely, intention to settle there, to use the significant word adopted by the recent English cases, animus manendi. As temporary absence cum animo revertendi from a former place of abode does not destroy domicile there, so temporary presence in a new place sine animo manendi does not establish domicile there, and this is so even if animus non revertendi be made to appear. A person's being at a place is prima facie evidence that he is domiciled at that place, but this prima facie disappears whenever it is shown that he was formerly domiciled elsewhere, and is not where he is now found cum animo manendi. With respect to the nature of the animus manendi there has been considerable confusion and conflict, particularly in this country, largely growing out of the practice among American judges of relying, without sufficient discrimination, upon cases of municipal domicile as authorities in cases involving questions of national or quasi-national domicile. Section 163. Id. Roman law. The Roman law throws little light upon the nature of the animus manendi. It devotes itself to the enumeration of the most usual and striking, and therefore the most important, external physical evidences of domicile, rather than to a description of the animus requisite for the establishment of domicile. About the only direct light which it throws upon the inquiry is contained in the words used in the definition given in the code, undrersus non sit dissessores, si nihil avesset, and this light is but feeble and uncertain. Upon the whole, however, we are left to infer that the domicile or home which it so pathetically describes, could not be a mere temporary abode, inasmuch as the evidences which it enumerates are in a general way evidences of permanency. And moreover the code contains a provision, following the ordinance of Hadrian, that residence in a place for the sake of study should not be deemed to confer domicile there unless such residence had been continued for 10 years, and the same rule was applied to the father of a student whose residence was chosen for the sake of being near his student son. According to Savini, such residence thus prolonged merely raised the presumption of a purpose of constant residence, and so it was understood by others. By its terms this provision of the code applied only to the cases of the student and his father, but this was probably only the particular application of the general principle that residence in a place for a special and temporary purpose does not constitute domicile, and thus understood it goes far to corroborate the inference above referred to, that permanency was an essential ingredient in the Roman idea of domicile. Section 164. Id. Continental jurists. Menicius remarks, 8 primum dicendum est habitationem et domicilium inter se differnam domicilium habeat quis dissiter in loco qui animo ibi commerandi perpetuo habitat is vero qui proemption aliqui ex causa, puta studiorum, volitus, vol simili commerita habitare dista. Donellis says, habitatio non est satis, animum consistendi accedere portet, ut quis solicitit ibi habitet, ut ibi sedem sibi constituerit, id dist. Ut ibi perpetuo consistat, non temporis causa, nisi aliquid indaviset. Quisquis temporis causa aliqubi commerita et consistit, ibi domicilium non habet. Veluti, sici legationis causa alico venerint, et dum legation funguntia, ibi habitationem conduxerint, sici venerant alico negociandi, aut mercata dissent causa. Ipsia deo studiosi, qui alico venerint studiorum causa. Hoc ipso, quod ibita consistent, ut post studia compulta domum redeant, quanto cunctempori ibi constituerint, tamen ibi domicilium non habent. John Voet says, illud certum est. Domicilium constitui. Nec solo habitation, sine proposito illic perpetuo mirandi. Sos angelus, non enim exeo, quod quis focum et ignum tenit. Arguitia domicilii constitutio, ut poet, que ex solo animo perpetuo habitandi in loco dependit. The French, like the Roman, jurists have been more inclined to look at the external evidences which indicate the setting up of a principal establishment than to inquire into the nature of the animus manendi. Nevertheless they insist upon substantial permanency. Thus de Molumb, in pointing out the similarity between the definition contained in the Roman Code and that of the Code Civil, namely, le domicile de tout franchise, est tolu uil sun principal établissement, says, that is to say, at the place which he has made the centre of his affections, of his affairs, and of his habits, the seat, in fine, of his social existence, rerum si fortunarum sarum summam, at the place where he is established in a manner permanent and durable, with the intention of being held there, of being there attached, of their returning sooner or later whenever he is absent. Again, in arguing against the possibility of a Frenchman acquiring a foreign domicile in complete derogation of his French domicile, he says, I add that the establishment of a Frenchman in a foreign country, so long as he has not been the naturalized, does not present the characteristics of duration and fixity which constitute domicile. The Frenchman is always presumed to preserve l'esprit de retour, and hence to be in a foreign country only more or less temporarily. And again, in speaking of the circumstances which may take the place of formal declarations, he says, that which is above all necessary, when the translation of domicile is in question, is that they should give evidence at once of the complete abandonment of the old place and the definitive adoption of the new. It is then, particularly, that habitation in the new place ought to present the characteristics of legal possession, that is to say, they ought to have nothing transient, provisional, or accidental. Section 165. Id. Savini thus defines domicile, that place is to be regarded as a man's domicile which he has freely chosen for his permanent abode, and thus for the centre at once of his legal relations and his business. The term permanent abode, however, excludes neither a temporary absence nor a future change, the reservation of which faculty is plainly implied. It is only meant that the intention of mere transitory residence must not at present exist. Residence not accompanied with the present intention that it is to be permanent and perpetual does not constitute domicile, even if by accident it continues for a long time, and therefore is not merely transient. Vattel Square defines domicile to be the habitation fixed in any place with an intention of always staying there, and his definition has been very frequently cited, commented upon, and criticized in England and America. Calvo quotes, as in his opinion the most exact, a definition which he attributes to Judge Rush, but which is in fact the definition of Judge Rush somewhat modified by Phillimore, namely, domicile is a residence at a particular place, accompanied with positive or presumptive proof of an intention to remain there for an unlimited time. It will thus be seen that the continental jurists, although differing among themselves perhaps with respect to the degree of permanency, agree in requiring for the animus manendi the character of substantial permanency. and this they require for all grades of domicile, whether national, quasi-national, or municipal. Section 166. Id. British authorities. In the British cases and by the British text writers, several forms of expression have been used to characterize the animus manendi, the one most frequently used being the word permanent, and it has been found for practical purposes sufficiently explicit. For an unlimited time and for an indefinite time have been also used, the latter in a few cases, and the former, through the influence of Phillimore's definition, given above, and more recently through the influence of Lord Westbury's remarks in Udny v. Udny, in a number. But it will be found that both of these expressions have almost invariably been used as equivalents of a permanently. In the earlier English cases, not so much stress was laid upon the character of the animus manendi as has been of late years insisted upon. The decisions in the cases of the servants of the East India Company, if explained upon any other ground than that given above, are not in accordance with the most approved definitions of domicile, and as we have already seen, the doctrine contained in them has been of late repudiated. Kindersley, V.C., who appears to have given a great deal of attention to the subject of domicile, in Lord V. Colvin, framed the following definition for the express purpose of providing for them: that place is properly the domicile of a person in which he has voluntarily fixed the habitation of himself and his family, not for a mere temporary and special purpose, but with the present intention of making it his permanent home, unless and until something, which is unexpected or the happening of which is uncertain, shall occur to induce him to adopt some other permanent home. If the word improbable were substituted for the word uncertain, we should here have as accurate a definition of domicile of choice, at least so far as concerns the animus manendi, as it is probably possible to frame. But the definition as given was disapproved by Lord Chelmsford in the same case on appeal in the House of Lords. It was there argued by appellant's counsel that intention to remain for an indefinite time was sufficient, but this doctrine was expressly repudiated. Lord Chelmsford remarking, "The learned counsel for the appellants contended for a definition of domicile far less precise and exact than any which has ever been suggested." They argued that a domicile was acquired whenever a person went to reside in a place for an indefinite time. Now, this definition and that of the Vice-Chancellor appear to me to be liable to exception in omitting one important element, namely, a fixed intention of abandoning one domicile and permanently adopting another. The present intention of making a place a person's permanent home can exist only where he has no other idea than to continue there without looking forward to any event, certain or uncertain, which might induce him to change his residence. If he has in contemplation some event, upon the happening of which his residence will cease, it is not correct to call this even a present intention of making it a permanent home. It is rather a present intention of making it a temporary home, though for a period indefinite and contingent. And even if such residence should continue for years, the same intention to terminate it being continually present to the mind, there is no moment of time at which it can be predicated that there has been a deliberate choice of a permanent home. Section 167. Id. These expressions and others in the same case and in the case of Wicker v. Hummel, decided by the House of Lords a few years before, in which Lord Wensleydale said, "One very good definition is this: habitation in a place with the intention of remaining there forever, unless some circumstance should occur to alter his intention," as well as several decisions shortly afterwards made by the Court of Exchequer, seem to go to the full length of Vattel's definition. But in the latest cases there has been some recession from that extreme doctrine. In Udny v. Udny, Lord Chancellor Hatherley says that the word settling, as we speak of a colonist settling in Australia or Canada, more nearly describes the act which a man does in adopting a domicile of choice than any other word in our language. Lord Westbury in the same case says, "Domicile of choice is a conclusion or inference which the law draws from the fact of a man fixing his sole or chief residence in a particular place, with an intention to reside there for an unlimited time. It must be residence, fixed not for a limited period or particular purpose, but general and indefinite in its future contemplation." And this is now generally acquiesced in as an accurate statement of the British doctrine upon the subject. Section 168. Id. Intention to remain for an indefinite time. The phrase indefinite time, so common in the American cases, is rarely used in the English, and then, except in Morehouse v. Lord, where the idea is expressly repudiated, and in several cases by Bramwell, B., and Brett, L. J., only as equivalent to unlimited time, the sense in which it is used in the American municipal domicile, and a few other cases, being expressed by Lord Wensleydale in Aikman v. Aikman, as residence for a definite time, though of uncertain duration. And this, he adds, would not, I conceive, confer a domicile. Section 169. Id. Intention to remain during the life of another. Whether intention to remain during the life of another person is a sufficient animus munendi for the constitution of a domicile of choice, is not settled. In Anderson v. Les Neuville, decided by the Privy Council, the affirmative was held under the following circumstances: A, whose domicile of origin was Irish, at the age of 19, being in France for his education, formed an attachment for L, who saved his life during the French Revolution and procured his escape to England 40 years afterwards. Having in the meantime acquired an English domicile, he ascertained the whereabouts of L, and joined her in France and lived there with her for 13 years, until his death, in a house which he bought jointly with her. There was evidence that he had repeatedly declared his intention of returning to England in case L predeceased him, and on the other hand his intention of remaining in France as long as she lived was clear. Dr. Lushington, speaking for the Privy Council, said, "It was contended that the testator only intended to remain during Madame Le Neuville's lifetime. Assuming that to be the fact, assuming that he intended to quit when Madame Le Neuville died, it does not at all follow that will establish the conclusion that he had not acquired a domicile in France. Because what is it that takes off the acquisition of a domicile by long residence in a country? It is being there for a temporary purpose. It never can be said that residing in a country till the death of a party was a temporary purpose." In Attorney General v. Countess de Walstadt, the Court of Exchequer took the opposite view. The testatrix, an unmarried woman, whose domicile of origin was English, had for 14 years resided with her sister, who was married and domiciled at Baden-Baden, in Germany, and the evidence was uncontradicted that it was her intention to remain with her sister as long as the latter lived. In the view which the court took of the facts, the intention of the testatrix beyond the life of her sister was not clearly shown, if indeed any had been definitely formed. Upon these facts the domicile of origin of the testatrix was held to continue. It must be remarked, however, that this was one of the intermediate cases between Morehouse v. Lord and Udney v. Udney, whose authority has been considerably shaken by the latter case and its sequence. But whether Anderson v. Les Neuville or Attorney General v. Countess de Walstadt express the better doctrine, or whether they may be reconciled, it is clearly impossible to lay down a strict rule that intention to remain for the life of another is or is not a sufficient animus munendi. In each of the cases referred to, the person whose domicile was in question, and the cestui cavi were of about the same age. Suppose, however, that the expectation of life of the former had been greatly in excess of that of the latter, or the reverse. If a young and vigorous person go to reside with one who is old and feeble, intending to remain during the lifetime of the latter, and to return upon his death, would a change of domicile be held? Or take the converse, and suppose that an aged and infirm parent should follow a young and vigorous child to a new country, intending to end his days with him if possible, but without any intention of remaining in case his child should die first, would not, in such a case, a residence sufficiently permanent to constitute domicile be contemplated? Section 170. Id. American authorities. In America there has been considerable conflict of opinion, and certainly much looseness of expression, with respect to the requisite animus munendi. This has been due to several causes, the principal of which have been, 1. The application of the doctrine of domicile to a large variety of frequently very diverse subjects. 2. The legislative habit of using such words as residence, inhabitancy, and the like as approximate terms to describe connection between person and place, leaving to the courts the duty of determining their true meaning in accordance with the general tenor, object, and scope of the particular legislation in which they are used. And 3. the too frequent practice of relying upon cases of municipal domicile as authorities in cases of national and quasi-national domicile. In most of the cases, however, in which the subject is at all considered, intention to remain permanently is either laid down or assumed as the necessary animus manendi. In many it is strongly insisted upon, some cases even going to the extent of adopting Vattel's definition either in terms or in substance. President Rush, in the leading case of Guy v. O'Daniel, defines domicile to be residence at a particular place accompanied with positive or presumptive proof of continuing it an unlimited time, and through the influence of this definition, particularly in its modified form as given by Phillimore, intention to remain for an unlimited time has been adopted in a number of the American cases. Section 171. Id. Intention to remain for an indefinite time. In many of the cases intention to remain for an indefinite time has been considered as sufficient. This phrase was originally used doubtless as synonymous with unlimited time, but through the influence of the cases of municipal domicile has sometimes received a much different construction. It is unfortunate that the word indefinite has been used at all in this connection, as it is at best a vague term, and may mean much or little, as happens. For in a certain sense intention to remain for life is but intention to remain for an indefinite time, while in another sense residence for the merest temporary purpose may be residence for an indefinite time. Thus intention to remain during the building of a house, though it took but 29 days, or from spring to the fall or winter of the same year, until a tin peddler could no longer travel on wheels, has been held to fall within the meaning of the phrase, and to work a change of municipal domicile. From such cases this doctrine has crept into cases of quasi-national domicile. Thus, in Sleeper v. Page, a Massachusetts case, we find it laid down, if his residence out of the Commonwealth was but temporary, yet if the time of his proposed return was indefinite, he retained no domicile in the Commonwealth, and to the like effect are several other cases. It is obvious that these cases are in utter conflict with all the foreign authorities, British and continental, as well as the best considered American decisions, and if followed in cases involving questions of private international law, can only introduce confusion by wholly breaking down the distinction between domicile and temporary residence. Who, for instance, would seriously think of submitting to such a test questions of testamentary capacity, personal succession, capacity for legitimation per subsequens matrimonium, or the like? But in the face of such loose views, it is not surprising to find several main judges carrying them to their logical conclusion by suggesting that the true test is simply intention to remain, whether for a definite or an indefinite time, and that therefore residence, accompanied with intention to remain for a term of years, would work a change of quasi-national domicile. Section 172. Much of the confusion on this subject in the American cases is traceable, directly or indirectly, to misconception of the meaning of Story's oft-quoted passage, given above. But that illustrious jurist did not use the phrase indefinite time in the sense of mere uncertainty of duration, is plain from the language which he uses throughout the chapter on domicile in his work on the conflict of laws, and particularly from his definition of domicile, following Dr. Lieber, as a true, fixed, and permanent home, as well as from the language which he used on the bench. Section 173. Intention to make the new place the home of the party. Story says, two things then must concur to constitute domicile: first, residence, and secondly, the intention of making it the home of the party. And a large number of authorities, British and American, have followed him either in words or in substance. Home itself, when properly understood, suggests the idea of permanency, although, as the word has been frequently loosely used, some authorities, to prevent misconception, speak of permanent home as the thing a person must intend to set up in acquiring a domicile of choice. Thus Lord Cranworth says, in Wicker v. Hume, by domicile we mean home, the permanent home, and if you do not understand your permanent home, I am afraid that no illustration drawn from foreign writers or foreign languages will very much help you to it. Wickens, v.c., in Douglas v. Douglas, says, it seems to me, that the intention required for a change of domicile, as distinguished from the action embodying it, is an intention to settle in a new country as a permanent home. And Story himself, as we have seen, defines domicile as a true, fixed, permanent home, etc. Section 174. Id. Negative view of animus manendi, without any present intention of removing. A negative view of the animus manendi has sometimes been put. This has been expressed in the form of a definition, thus, that place is properly the domicile of a person in which his habitation is fixed without any present intention of removing therefrom. That this is inaccurate as a definition either of domicile in general or of domicile of choice, could easily be shown. Indeed, it was originally intended hardly as a formal definition, but rather as a protest against, and an approximate correction of, the too narrow definition of Vattel. Its author was Parker, J., who, in Putnam v. Johnson, a case of municipal domicile, used the following language: the definition of domicile, as cited from Vattel by the counsel for the defendants, is too strict, if taken literally, to govern in a question of this sort, and, if adopted here, might deprive a large portion of the citizens of their right of suffrage. He describes a person's domicile as the habitation fixed in any place, with an intention of always staying there. In this new and enterprising country it is doubtful whether one half of the young men, at the time of their emancipation, fix themselves in any town with an intention of always staying there. They settle in a place by way of experiment, to see whether it will suit their views of business and advancement in life, and with an intention of removing to some more advantageous position if they should be disappointed. Nevertheless, they have their home in their chosen abode while they remain. Probably the meaning of Vattel is, that the habitation fixed in any place, without any present intention of removing therefrom, is the domicile. At least, this definition is better suited to the circumstances of this country. But thus explained, however applicable to cases of municipal domicile, it is inapplicable to cases of national and quasi-national domicile, a tentative settlement or contingent animus manendi, such as that referred to, being insufficient for the acquisition of such domicile, and, a fortiori, the mere absence of intention as to future residence would be insufficient. For the acquisition of domicile there must be animus manendi of some description. It is possible that this is implied in the words habitation fixed. But what are we to understand by these words? Certainly not mere physical presence. There must be something more than that. Would residence for a special and temporary purpose, there being no animus revertendi, and no intention of any kind with regard to the future, after the accomplishment of such purpose, be sufficient? Clearly not. For in such case, according to the great weight of the authorities, the prior domicile would be presumed to continue. Or do the words contemplate the manner of living? Probably not. It will be observed that in all the cases of national or quasi-national domicile in which this negative description of the animus manendi has been used, there has been evidence more or less strong of intention to remain for an unlimited time. Section 175. Id. Animus manendi does not exclude the possibility of change. But whatever may be the nature of the requisite animus manendi, it cannot be understood as excluding or even restricting the possibility of future change. The power to change, being of the essence of domicile, is always reserved, even if we adopt the strictest possible view of the animus manendi. Domicile is not only freely chosen, but freely changed, by one who is sui juris, and even though he intend to remain in a new place of abode always, or for life, he is at liberty to change his intention and adopt another place as circumstances may require or caprice suggest. It is, therefore, necessary in solving a question of change of domicile to confine ourselves closely to the point of time at which the change is alleged to have occurred, and to bear in mind that subsequently formed intention is not only not determinative, but is very frequently misleading. Section 176. Id. Contingent animus manendi not sufficient. A mere conditional or contingent animus manendi is not sufficient. Thus, where a citizen of Illinois went to Tennessee, intending to settle there, if the country suited him, it was held that he did not thereby gain a domicile in Tennessee. So in the case of Bell v. Kennedy, in the House of Lords, B. left his domicile of origin in Jamaica and went to Scotland, intending to settle there permanently, if he could find an estate to suit him. In this he failed up to the time when his domicile became important, and it was held that his domicile of origin continued, and this although he had no intention of returning to it in any event. This point is also illustrated by the case of Craigie v. Lewin, already referred to. Section 177. Id. Intention to reside presently necessary. Again, it is necessary that the intention should be to reside presently as well as permanently. Personal presence, coupled with intention to begin in future a residence of however permanent character, is not sufficient. Thus, in the case of Attorney General v. Dunn, an Englishman went abroad and purchased the title, castle, and estate of R. in the Papal States, and expended a large sum of money in fitting up the castle for his future permanent residence. He died in Rome while the improvements were still going on, having in the meantime returned to England, and spent much of his time in travelling. The court held that, his intention having been only to take up his residence at R. at a future time, his English domicile continued. So in Carey's appeal, the testator, who had lived in Pennsylvania upwards of 40 years, but had subsequently become domiciled in Rhode Island, stopped at Philadelphia en route to the south, where he intended to spend the winter, and while in Philadelphia expressed his intention to return there to reside permanently, and directed his son-in-law to look for a house for him in that city, to be taken on his return from the south the next spring. But it was held that, as he contemplated, not an immediate, but a future settlement in Pennsylvania, his Rhode Island domicile remained. In Hall v. Hall, it was held that one who came into the state of Wisconsin and engaged a lodging place, but without occupying it left the same day, intending to return, and went into other states to transact business, did not acquire a domicile in Wisconsin until his subsequent return. Whether a married man who has gone into another state for the purpose of selecting and preparing a home for himself and family, and who has actually selected and prepared such home, thereby acquires a domicile, notwithstanding his intention to return for the purpose of bringing his family to the new place of abode, is a question left in some doubt by the apparent conflict of the decisions, although the weight of authority appears to be in favor of the affirmative. Section 178. Animus need not be present at the time of removal, it may grow up afterwards. It is not necessary, however, that the animus should be present at the time of removal. It may grow up afterwards, and engraft itself upon a residence, originally taken for a special or temporary purpose, so as to transmute it into domicile. In Udney v. Udney, Lord Westbury said, residence originally temporary, or intended for a limited period, may afterwards become general and unlimited, and in such a case, so soon as the change of purpose, or animus manendi, can be inferred, the fact of domicile is established. Section 179. At what point of time domicile vests and is divested? All that is necessary for the acquisition of a domicile of choice is that the factum and the animus should at some time coexist. That absence from the old place of abode and presence in the new should concur with intention to abandon the old and presently and permanently reside in the new. And as the new domicile vests instantly upon the concurrence of the elements which are necessary for its acquisition, so too the old domicile is instantly divested. This results necessarily from the application of the principle that no person can have more than one domicile at the same time. Whatever may be the mental processes of the person whose domicile is in question, in law the loss of the old and the acquisition of the new domicile are coincident as well as correlative. The one depends upon the other, and they happen at the same instant of time.